Earlier today, Sidney Powell met with a federal judge to discuss decertifying Georgia's election results. Now, in this particular case, the federal judge dismissed her lawsuit, claiming that there were a bunch of issues with it and that they couldn't carry forward with it. Now, what I'm going to do at the end of me talking about this here, I'm going to include the audio clip between her and the judge discussing this so that you can hear the whole thing for yourself. And I'll put a timestamp in the video below so that you can go to that exact spot. If you want to hear the whole thing for yourself and you have time to do so, go click on it and listen to the whole thing. But we're going to discuss some of the highlights from it before we get to that. So here's what went down. The federal judge dismissed the election fraud lawsuit led by President Trump supporter Sidney Powell. Judge Timothy C. Batten dismissed the suit after hearing arguments that lasted just over an hour Monday, citing moot arguments, lawsuit timing, and arguments filed in the wrong court. This happened at the same time Georgia officials were preparing to recertify the election after ballots were counted 3 times, including a hand and machine recount. The latter was requested by the Trump campaign following a state audit of the general election. Powell sought to decertify the election results and have voting machines examined. She also argued for new electors to be appointed, something that would not be permitted per federal and state law, according to them here. The fraud allegations in the suit are parallel to dozens of allegations that have been dismissed in federal courts nationwide since the general election. Part of Batten's decision includes the following remarks. Sometimes federal judges are criticized for committing the sin of judicial activism. We call the courts that have responded to that enough is right. In fact, enough is too much. And the courts have convincingly held these types of cases are not properly before federal courts. These are state elections. State courts should evaluate the proceedings from start to finish. Moreover, the plaintiffs simply do not have standing to bring these claims. They say by saying the relief Powell sought could not be ordered by the federal court. So essentially, they're shirking off the responsibility for this. It's not their purview. They don't oversee this. This is a state matter, and she needs to go before the states, not the federal courts. So they go on to say, additionally, I find that the plaintiffs waited too long to file this suit. Their primary complaint involves the Dominion ballot marking devices. They say those machines are susceptible to fraud. There is no reason they could not have followed the Administrative Procedure Act to the rulemaking authority that has been exercised by the Secretary of State. This suit could have been filed months ago at the time these machines were adopted, Batten concluded. Instead, the plaintiffs waited until over 3 weeks after the election to file suit. There's no question in my mind that if I were to deny the motion to dismiss, the matter would be brought before the 11th Circuit, and the 11th Circuit would reverse me. So this argument that there is not enough time, she waited too long to do this, she discusses this in the conversation, the audio you can listen to later, and how they have spent this time gathering the evidence, and they just got it, and they're presenting it, and they literally say they only need just a little bit more time to get access to the machines and show and prove all of the stuff they're saying here definitively. All they just need is, the access to this to show they can do it. So that is pretty much what they have to say in the article here. But again, I'm going to play you the whole thing, and none of the coverage of this really represents exactly what was said. Sidney Powell makes all the arguments herself, so you can listen to her. And she makes some very good points, and some of the stuff's just almost laughable. That, the judge's response at one point says, even if this went through and we decertified, would that even mean Trump would win? Would Trump win in this outcome? That's not the big issue. That's not why these lawsuits need to be brought forward and need to be heard, and things need to be, corrected and make sure everything is on the level. It's not whether or not Trump wins or loses. The point is that there is belief that there was fraud in the election system, and the election system needs to be trusted. And she is making the case here that they can prove there was fraud, and this needs to be addressed. And it shouldn't matter if it doesn't change a thing about the election or whether it does. It's the fact that they believe there is fraud, and that needs to be looked into. So it shouldn't really matter if the results of that all of a sudden make Trump win or don't help Trump at all. That's not a factor in it. Factor is whether or not there was fraud. But that's enough of me talking about it. I'm going to go ahead and play you the audio clip now. Thank you guys for tuning in this segment. We'll see you next time.
Equipment and software systems are not properly protected, implemented, and audited. The modality of these systems' capacity to deprive voters of their cast votes without burden, long wait times, and insecurity regarding how their votes are actually cast and recorded in the unverified QR code makes the potential constitutional deprivation less transparently visible as well, at least until any portions of the system implode because of system breach, breakdown, or crashes, all of which the state of Georgia experienced. Any operational shortcuts now in setting up or running election equipment or software creates other risks that can adversely impact the voting process.
The question is, can you?
No, Your Honor, we can't. These are exclusively federal claims with the exception of the election contest allegation. They're predominantly federal claims. They're brought in federal court for that purpose. Problems discussed in that 3-day hearing she held have now manifested themselves within the state of Georgia in the most extreme way possible.
You did not address the question before the court today, though, as to the propriety of bringing this suit in this court, did she?
There's no other place to bring this suit of federal equal protection claims and the electors.
You couldn't bring all these claims in state court? Is that your position?
We're entitled to bring these claims in federal court, Your Honor. They're federal constitutional claims.
Well, what do you do with the 11th Circuit's holding in Wood on Saturday that we cannot turn back the clock and create a world in which the 2020 election results are not certified?
Well, actually, we can, but we don't need to because we're asking the court to decertify.
Well, where does that exist?
Bush versus Gore. Bush versus Gore was a decertification case. There are other cases we've cited in our brief that allow the court to decertify. And at the very minimum, this court should order a preliminary injunction to allow discovery and allow us to examine the forensics of the machines. For example, we know that already in Ware County, which is a very small precinct, there were 37 votes that were admittedly flipped by the machines from Mr. Trump to Mr. Biden. That's a 74-vote swing. That equates to approximately the algorithm our experts also believe was run across the state that weighted Biden votes more heavily than it did Trump votes. That is a systemic indication of fraud that Judge Totenberg was expressing concern about in her decision just weeks before the election. We have witness after witness who have explained how the fraud can occur within the machines. We know, for example, that there were crashes, just like she feared in the decision and everybody expressed concern about. We know machines were connected to the internet, which is a violation of their certification requirements and federal law itself. We could not have acted more quickly. In fact, the certification issue wasn't even ripe until it was actually certified.
You weren't limited in your remedies to attacking the certification. You could have attacked the machines months ago.
That's what happened in the Totenberg decision, and that's why I read it to the court. The machines were attacked by parties, and the election was allowed to go forward, and we have come forward with our claims as fast as is humanly possible. This is a massive case and of great concern, not just to the nation and to Georgia, but to the entire world, because it's imperative that we have a voting system that people can trust. They talk about disenfranchising voters. Well, there are over 1 million voters here in Georgia that will be disenfranchised by the counting of illegal ballots that render theirs useless. It's every legal vote that must be counted. Here we have scads of evidence. And the vote count here is narrow. I mean, the disparity now is just a little over 10,000 votes. Just any one of our categories that we've identified require decertification. For example, 20,311 non-residents voted illegally. Between 16,000 and 22,000 unrequested absentee ballots were sent in violation of the legislative scheme. Between 31,000 and 38,000 absentee ballots were returned by voters but never counted. 32,347 votes in Fulton County were identified to be statistically anomalous. And the vote spike for Mr. Biden that is completely a mathematical impossibility, according to multiple expert affidavits we've provided, shows that it was like 120,000 Biden votes all of a sudden magically appear after midnight on election night. That happens to coincide with the time we have video of the Fulton County election workers running the same stack of rather pristine-looking ballots through the machine multiple times. And as for the recount, that makes no difference, because if you recount the same fake ballots you achieve in the same machines, you achieve the same results. That's why the hand count in Ware County that revealed the 74 swing is so important and indicative of the systemic machine fraud that our experts have identified, and why it's so important that we at least get access for the Department of Defense even, or our own experts, or jointly, to examine the machines in Fulton County and the 10 counties we requested in our protective order, or our motion for.
How is this whole case not moot from the standpoint of, even if you were to win and win Georgia, could Mr. Trump win the election?
Well, fraud, Your Honor, can't be allowed by a court of law to stand.
Well, that's not what I'm asking. I'm not saying there may not be other issues that need to be addressed and that there might not be questions that need to be investigated. I'm asking, as a practical matter, in this particular election, can Mr. Trump even win the election, even if he wins Georgia?
Yes, he can win the election.
How would that happen?
Because there are other states that are still in litigation that have even more serious fraud than we have in Georgia. It is nowhere near over. And it doesn't affect just the presidential election. This fraud affects Senate seats, congressional seats, gubernatorial seats. It affects even local elections. Another huge statistic that is enough by itself to change the result is the at least 96,000 absentee ballots that were voted but are not reflected as being returned. All of these instances are violations of federal law as well as Georgia law. In addition, Mr. Ramsland's report finds that the ballot marking machine appears to have normally influenced election results and fraudulently and erroneously attributed between 13,725,000 and the 136,908 votes to Mr. Biden just in Georgia. We have multiple witnesses who saw masses of pristine ballots appearing to be computer marked, not hand marked, and those were repeatedly run through machines until votes were injected in the system that night without being observed by lawfully required observers in violation of Georgia and federal law, that resulted in the mass shoot-up spike of votes for Mr. Biden. Mr. Favorito's affidavit is particularly important. He talks about the Ware County Waycross City Commission candidate who reported that the Ware County hand audit is flipped those 74 votes. That is a statistically significant swing for a precinct that small, and there's no explanation for it other than the machine did it. We have testimony of witnesses who saw that their vote did not come out the same way it was. Mr. Favorito is a computer tech expert. He said that the vote flipping malware was resident on the county election management system of possibly one or more precinct or scanners. There was also an instance where it came out of the Arlo system changed, and there was no way to verify the votes coming out of the individual precincts versus coming out of Arlo, because apparently they didn't keep the individual results so that they can be compared. So there was a vote swapping incident through the Arlo process also. There was a misalignment of results, according to Mr. Favorito, among all three presidential candidates, rather than just a swapping of the results for two candidates. In other words, they would sometimes put votes into a third-party candidate and take those out and put them in Mr. Biden's pile. The system itself, according to its own technological handbook, explains that it allows for votes to be put in. It can scan to set or overlook anything it wants to overlook, put those in an adjudication pile, and then in the adjudication process, which apparently was conducted in top secret at the English Street warehouse, where all kinds of strange things were going on, were just thrown out. They could just literally drag and drop thousands of votes and throw them out. That is why it is so important that we at least get temporary relief to examine the systems and to hold off the certification or decertify or ask the court to halt the proceedings continuing right now until we can have a few days to examine the machines and get the actual evidence off the machines and look at the ballots themselves, because we know there were a number of counterfeit ballots that were used in the Fulton County count that night. It would be a simple matter to examine 100,000 or so ballots and look at which ones are fake. It's possible to determine that with relative ease. This is not about who or which government officials knew anything was wrong with the machine. It's entirely possible that many people did not know anything was wrong with them. But it is about ensuring the integrity of the vote and the confidence of the people that the will they expressed in their vote is what actually determines the election. Very few people in this country have any confidence in that level right now. Very few. The standard is only preponderance of the evidence. We have shown more than enough for a prima facie case to meet the standard required that this court is required to apply. It is crucial that we decertify and stop the vote. We need to have discovery. It's so important to the American people, particularly in a country that is built on the rule of law, to know that their election system is fair and honest.
That rule of law limits where these suits can be filed and who can bring them. Specifically on the standing issue, how did your clients survive the motion to dismiss with respect to the standing issue if I don't follow the Eighth Circuit's case and opinion in Carson?
Well, even the court's decision in Wood is so distinguishable, it should make clear electors have standing. In that case, for example, the state could not even say who did have standing, but under the Constitution, electors clearly do.
But Georgia, unlike Minnesota, differentiates between candidates and presidential electors, right?
I'm not sure about that, but we also have the Cobb County Republican Party official who is suing, and the electors themselves are part of the constitutional clause that entitles them to standing. I think the third...
You have a pretty glib response to what the 11th Circuit has held regarding these cases. I mean, the 11th Circuit has basically said, we're not, the federal courts are courts of limited jurisdiction, and we're not open 24/7 to remedy every freewheeling constitutional issue that comes up. They have made it clear, the appellate courts have made it clear that they don't want district courts handling this matter. They want state courts handling state election disputes, even regarding in federal elections. The federal government has nothing to do with the state election, how it was conducted, as you said. It's the Secretary of State who is the chief election officer and decides it. Why shouldn't the state of Georgia investigate this? Why should it be a federal judge?
Because we raise federal constitutional issues that are paramount to equal protection. He did not request decertification. That's one of the things that distinguished that case. He was not an elector or a representative of a county. He was simply an individual. And I'm not sure that decision is correct, because in that case they were also wondering who could challenge it. Well, obviously, the Federal Equal Protection Clause and the constitutional issues we have raised here give this court federal question jurisdiction. This court's one of the primary checks and balances on the level of fraud that we are experiencing here. It's extremely important that this court exercise its jurisdiction as a gatekeeper on these issues. There were numerous departures from the state statute, including the early processing of votes and the de facto abolition of signature matches that give rise to federal equal protection claims.
Allege the plaintiffs that, quote, all candidates, political parties, voters, including without limitation plaintiffs, have a vested interest. It doesn't sound like your clients are special. They have some unique status that they enjoy that allows them to bring the suit instead of anyone else.
They have the unique status of being the presidential electors selected to vote for Donald Trump at the Electoral College. They were not certified, and decertification is required to make sure they can do their jobs that they were selected to do.
Does your theory survive?
Our theory is, I think the Third Circuit decision is wrong. The Eighth Circuit decision is correct. There's no circumstance in which a federal elector should not be able to seek relief in federal court, thanks to our Constitution. It's one of our most important principles. There were multiple means of fraud committed here. We have also the military intelligence proof of interference in the election, the Ware County 37 votes being flipped, the video of the Fulton City vote count. They lied about the water leak. They ran off observers. They brought in unusually packaged ballots from underneath the table. One person is seen scanning the same QR code 3 different times in the machine in a big batch of ballots, which would explain why the same number of ballots gets injected repeatedly into the system. That corresponds with the math and the algorithms showing a spike of 26,000 Biden votes at the same time. After Trump's lead of 103,997 votes, there were mysteriously 4,800 votes injected into the system here in Georgia multiple times, the same number, 4,800 repeatedly. That simply doesn't happen in the absence of fraud. All of the facts we have laid out in our well-pleaded complaint require that this court decertify the election results, or at the very least, stop the process now in a timely fashion and give us an opportunity to examine the machines in 10 counties and get further discovery, particularly of what happened in Fulton County. Those things need to be resolved before any citizen of Georgia can have any confidence in the results of this election. Allowing voters to cast ballots that are solely counted based on their voting designations and not on an unencrypted, humanly unverifiable QR code that can be subject to external manipulation and does not allow proper voter verification and ballot vote auditing cannot withstand the scrutiny of a federal court and cannot pass muster as a legitimate voting system in the United States of America. For those reasons, we request the court deny the motion to dismiss, allow us a few days, perhaps even just 5, to conduct an examination of the machines that we have requested from the beginning and find out exactly what went on and give the court the further evidence it might want to rule in our favor, because the fraud that has happened here has destroyed any public confidence that the will of the people is reflected in their vote and just simply cannot stand.
Thank you, ma'am. All right. Thank you very much. I have considered the entire record in the case, and I find that even accepting through every averment of the complaint, I find that this court must grant the defendant's motions to dismiss, both of the motions to dismiss. Begin with the proposition that federal courts are courts of limited jurisdiction. They are not the legal equivalent to medical hospitals, which have emergency rooms that are open 24/7 to all comers. On the contrary, the 11th Circuit has specifically held that federal courts don't entertain post-election contest about vote counting and misconduct that may properly be filed in state courts. So whether the defendant has been subjected to a federal claim, exception, due process, elections clause, it does not matter. The 11th Circuit has said these claims in this circuit must be brought in state court. There's no question that Georgia has a statute that explicitly directs that election contest be filed in Georgia Superior Courts, and that's what our federal courts have said in this circuit that's exactly right. Sometimes federal judges are criticized for committing the sin of judicial activism. The appellate courts have responded to that and said enough is right. In fact, enough is too much. And the courts have convincingly held that these types of cases are not properly before federal courts, that they are state elections. State courts should evaluate these proceedings from start to finish. Moreover, the plaintiffs simply do not have standing to bring these claims. This court rejects the Eighth Circuit's non-binding, persuasive value only holding in Carson versus Simon, and I find that the plaintiffs don't have standing because anyone could have brought this suit and raised the exact same arguments and made the exact same allegations that the plaintiffs have made in their complaint. The plaintiffs have essentially alleged in their pleading that their interests are one and the same as any Georgia voter. I do not believe that the 11th Circuit would follow the reasoning of the 8th Circuit in Carson. Additionally, I find that the plaintiffs waited too late to file this suit. Their primary complaint involves the Dominion ballot marking devices. They say that those machines are susceptible to fraud. There's no reason they could not have followed the Administrative Procedure Act and objected to the rulemaking authority that had been exercised by the Secretary of State. This suit could have been filed months ago at the time the machines were adopted. Instead, the plaintiffs waited until over 3 weeks after the election to file the suit. There's no question in my mind that if I were to deny the motion to dismiss, the matter would be brought before the 11th Circuit and the 11th Circuit would reverse me. The relief that the plaintiffs seek, this court cannot grant. They ask the court to order the Secretary of State to decertify the election results as if such a mechanism even exists, and I find that it does not. The 11th Circuit said as much in the Wood case on Saturday. Finally, in their complaint, the plaintiffs essentially asked the court for perhaps the most extraordinary relief ever sought in any federal court in connection with an election. They want this court to substitute its judgment for that of 2.5 million Georgia voters who voted for Joe Biden, and this I am unwilling to do. The motion for the temporary restraining order that was entered on November 29 is dissolved. The motions to dismiss are granted, and we are adjourned.
All rise.